Creio que a transmissão foi iniciada. Boa tarde a todos que nos acompanham através do YouTube. Boa tarde às equipes. Nós iremos dar início em alguns minutos à rodada final da seletiva brasileira da 25ª Stetson International Environmental Moot Court. Daqui a pouco daremos início, então, a esta rodada. Estamos apenas aguardando que todas as equipes terminem de entrar na sala. Tiara, você recebeu notícias da Maria Beatriz?
Rui, eu falei com ela, eu tô esperando ela me responder exatamente agora. Eu vou tentar fazer uma ligação para ela.
Certo.
Desculpa.
Tudo bem. Eu vou na sala dos juízes e já volto. Perfeito, estamos com todas as oradoras aqui, correto? Temos 3 pessoas como applicant, então calma, é a Maria Beatriz, que no caso será respondent, não é isso? É. Pronto, com todos aqui, podem já ligar suas câmeras, por favor, e já trarei os avaliadores. All right, can everyone hear me clearly? Perfect then. Okay, we will now begin the final round of the Brazilian rounds of the Stetson's International Environmental Moot Court Competition. For the last day, the teams have competed in a series of preliminary rounds, and now we have the two remaining teams here from Universidade Federal de Pernambuco and from Universidade Presbiteriana Mackenzie, which will battle it out for the spot to go to the international finals of the Stetson's IEMCC. So without further ado, for this round, me and Mariana Chorato will be serving as bailiffs for the round. And the case before this court is the case concerning questions relating to the protection of bats and international trade measures. The parties are the applicant, the federal states of Alducra, represented by team from Universidade Presbiteriana Mackenzie, and the respondent, the Republic of Rumberi, represented by the team from Universidade Federal de Pernambuco. The applicant and the respondent are each allocated 30 minutes to present their pleadings. In this round, we'll have as president, Judge Oliveira, Paulo Oliveira, and we'll also have as judges Lucas Lima and Juliette Robichet. So this court is now in session. I will bring the judges here so that the applicant may begin their pleadings upon approval by the president of the session. Okay, we have all the judges in this room. We have the bailiff, Mariana Chorato, alongside me. President Paulo Oliveira, you may allow the teams to proceed at your will.
Thank you, Rui. First agent for applicant, please, you have the floor.
Good afternoon, Mr. President, Your Excellencies, may it please the court. My name is Marcela Guerreiro Bruneto, and I have the honor to appear on behalf of the federal state of Alducra, the applicant in today's proceeding. I will speak for 30 minutes. My co-agent, Laura Rodrigues Gonçalves, will speak for 15 minutes. We would like to reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 30 minutes, I will be submitting that. First, Romeri's violated CBD. Second, Romeri violated some resolutions of CMS. Third, Alducra diplomatic note forward on January 2019 to Romeri was in accord with the resolution 7.5 of CMS. And fourth, Alducra actions were taken accordingly with the bat conservation measures in a climate change context. My co-agent, Laura Rodrigues, will demonstrate that. First, Romeri violated the duty to prevent transboundary harm. Second, Romeri's actions violated provisions of the Irabet Agreement. Third, Alducra complied with the Irabet Agreement. And fourth, Alducra did not violate international law in regards to trade measures for Tapegun products. Your Excellencies, our first argument is about CBD. Your Excellencies, Romeri breached the state.
Sorry for interrupting you, counsel. Do you think that this court has jurisdiction to adjudicate this case? A court with 3 judges.
Can you repeat, please?
A court with 3 judges. Do you think that this court has jurisdiction over this case?
We have a couple of jurisdictions that I will be submitting in my arguments.
But could you please answer me now if this court that has only 3 judges can decide this case?
This court can decide, but I don't have the information. It's any other judgment was made just by 3 judges.
Okay, thank you, counsel.
So Your Excellency's first argument about CBD. Your Excellency, Romeri breached the state's duty to inform Alducra about the wind farm project and its construction environmental impacts. CBD Article 14 established that the parties should promote the exchange of information concerning under their jurisdiction, which are likely to simply affect biological diversity of other states. The importance of the duty to notify can be recognized, for example, in the Pulpos case, in which the court determined that Uruguay was obligated by treaty to inform and consult with the neighboring state, Argentina, before providing the Pulpos project and authorizing its construction. By not notifying Alducra about the construction of the wind farm beforehand, nor sharing the information collected in its EIA with the neighboring country.
Do you have any other case to support your argument?
Yes, I also have the case aerial herbicide spraying between Ecuador and Colombia, which was on May 2008.
And never decided. The court never decided this case.
Yes, the court never decided this case, but this case went to the International Court of Justice, and the countries by making an agreement between them, which shows us a cooperation, which Romeri hasn't shown in this present matter.
Can you
the president
agent? Can you draw this? Can you draw a parallel between the facts of this case and the occurrent facts?
Yes, so Ecuador filed an application instituting the application against Colombia in respect of the disputes concerning the aerial spraying by Colombia of toxic herbicide at location near and across the border between Ecuador. So this aerial spraying was being really harmful for Ecuador. And we can see the same scenario here, which Romeri is doing a wind farm, which is being really harmful for biological diversity, by consequence for bats, and by consequence for Alducra. So by not notifying Alducra about the construction of the wind farm beforehand, nor sharing the information collected in its EIA with the neighboring country, having the knowledge that the area designated to the construction of the project is a bad migration road, and that those animals are of great importance to both countries, it is point to say that Romeri violated CBD. Getting to another point, Romeri violated the Convention on Migratory Species, CMS. The lack of regular monitoring of the wind farms by Romeri and post-environmental impacts do not fulfill CMS. CMS 7.5 resolution recognized a mistake: the lack of sufficient research on environmental effects of the wind farms and the lack of data on the distribution and migration of species concerned. And furthermore, it is concerned about countries regularly monitoring the white turbine plants. Romeri only made a study EIA during the project and the beginning of the works, and yet Romeri never released those studies. Furthermore, during the construction of the wind farms, Romeri stopped monitoring. And according with the Professor Thomas Fisher, which are an expert in EIA, the professor of the University of Liverpool, says that the whole project requires a multi-phase study. The EIA must be done in all phases, and Romeri has not done that. In this way, there is a violation of Romeri's government.
Sorry to interrupt your question, but you are invoking this professor in which capacity here in this case?
Next, according to the statute of the International Court of Justice, there are Article 38. In the trial, we may use other resources for our argument, such as
but your agreement. Sorry to interrupt you, but in your agreement, you did not mention other sources. You mentioned only treaty law and customary international law and principles, not scholarship. So why are you invoking scholarship if you decided not to do so in the agreement?
Your Excellency, because since we are in International Court of Justice, we thought that it would be really useful to use such an expert in this case. But if you want, I may use other resources about the EIA. So, for example, according to CBD, that is the agreement between these two parties are into. we must have the screening, the scoping, assessment, evaluation, report environmental impacts, review all the environmental impact assessment, decision-making, and to finish, monitoring, compliance, enforcement, and environmental auditing. Everybody has not done that.
Do you have any case to substantiate your claim regarding EAA?
I don't have that information.
Because we have some cases in this regard, but you may proceed.
So on the other hand, ALDUCRA diplomatic note forward on January 2019 to Rombetti was in accord with the same CMS resolution, the 7.5. By urging the concerns regarding the installation of the government subsidized wind farm on its neighboring country and its effect over migrant bat population, ALDUCRA acted accordingly with the CMS resolution. The resolution recalled parties to identify areas where migratory species are vulnerable to wind turbines and where wind turbines should be evaluated to protect migratory species. For example, according to the Eurobats publication 6, when wind turbines are proposed in areas of high bat activity or close to roots, they should be resited away from these areas. So ALDUCRA acting right when they sent a diplomatic note explicit there was indeed a negative impact on the Royal North population and to ask for the current suspension of the construction in that place, a bad migratory location. Perhaps is not enough, Rombetti also violated CMS resolution 11.27 by agreeing to the construction of the wind turbines on a migration.
Is it possible to violate a resolution?
Yes, your access is possible, even though resolutions are not binding, they are more similar with soft law. Resolutions are points that lawmakers really want to emphasize. And in the convention context, we can say that resolutions are a kind of reflection of the articles of the convention. So if the parties agree—
As judges declare that a resolution was violated?
Yes, we can say that the resolution was violated.
Has this court ever said that a resolution was violated? A non-binding document was violated? So you are asking this court to declare that a non-binding document was violated? Is this so? Is this your claim, counsel?
I had a couple of claims, but this is one of them, and it's not just that Rombetti violated the resolution, but I think it's important to consider that a resolution that is made by lawmakers must be in the scope of the scenario of this argument, since Rombetti hasn't followed his commitments with this resolution.
Thank you, counsel.
So according to the USGS Science for a Change Road, bats are being found dead close to wind turbines all over the world. Bat fatalities now have been documented at the most bat fatalities in US and Canada, and it's estimated that tens to hundreds of thousands bats die at wind turbines in North America each year. So nevertheless, Rombetti's its attempt to implement a sustainable source of energy agreed on the construction of wind energy project in the Royal North to Migration Road, a fact that according to the record, page 10, paragraph 17, the government of Rombetti was already aware of. Parentheses, above and beyond, Rombetti had other options of sustainable energy, and yet he chose the one that would directly affect the species mentioned in its migration road. In this context, the Bat Conservation Group, Shooterback Crusader, urged the Rombetti and PECO to implement mitigation measures for the construction and operations of the turbines, which they constantly denied to do. On that account, Rombetti did not attempt to use responsibility to preserve a species protected under international law. On the contrary, consolidate this wind energy project in such a way that the result could not be other than the constitutional raise of the Royal North to mortality. Next is getting to our last point. By opposing of the construction of the wind farm complex in its neighboring country, ALDUCRA is granting the appropriate measures shall be taken away to conciliate climate change situation alongside efforts to preserve bat population.
Before you enter the climate change argument, counsel, you mentioned the criteria of mortality as important to take into account. Has this court ever dealt with mortality in a case regarding environmental law or the protection of some species?
Your Excellency, I don't have exactly that information, but it's known that biological diversity is connected with our environment, and this court has already judged a couple of cases that involved environmental law, international environmental law. So that's why it's really relevant to consider biological diversity in this case.
Can you bring it up an example?
An example of a case?
Yes.
So, for example, in the pupils case, the case was because made the river would be really hard. I also have, how I said, the aerial herbicide spraying.
And what exactly the link between that case and the present case?
Well, this case is a herbicide. So a herbicide is really harmful for the. May I finish my point?
Briefly,
That's your phrase.
Okay, so in this case, the nature was affected and consequently animals were affected. So biological diversity was affected. So may it please the court, if I accept no further need of my assistant, I thank the court for his time and indulgence. It was an honor. Now I will pass the floor for my co-agent, Laura Rodriguez. Thank you.
Thank you, agent. The second agent for applicant, please, you have the floor.
Thank you. Good afternoon, Mr. President, Your Excellencies. My name is Laura Rodriguez Gonzalez, and I appeal on behalf of the Federal States of Valducra, the applicant in this case. I'll be addressing my speech for 15 minutes regarding the issues that, first, Rumberi violated the duty to prevent transboundary harm. Second, Rumberi's actions violated provisions of the Eurobats agreement. Third, Alducra complied with the Eurobats agreement. And my fourth and last point will be that Alducra did not violate international law in regard to its trade measures for tapagian products. So may it please the court, my first point will be that Rumberi violated the duty to prevent transboundary harm, in that by allowing the construction of the wind farm, Rumberi violated its duty to prevent transboundary harm.
Agent, please, in the record, I read that the bad deaths were not either occurred in Rumbeti, no?
Yes.
How can you speak about transboundary harm?
Yes, so the bats deaths were only in Rumberi, the respondent, but we can say there was transboundary harm because the bats are a shared resources. According to the United Nations Environmental Program, the Intergovernmental Working Group of Experts on Natural Resources shared by 2 or more states say that shared resources can be identified as natural resources located in the territory of more than one country or state, such as river systems, forest, and, as in the present case, migratory species. Also, we have to consider that any damage to a migratory species and to a species that is local to the area is a damage to biodiversity, and that transcends all borders. Also, we must consider that the bats deaths can also financially harm Alducra, because if we have this wind farm in a migration route close to the border between Alducra and Rumberi, the bats that would migrate to Alducra are likely to die due to the wind farm and then not migrate to Alducra. So Alducra also uses bats and only bat-safe farming practice for their agave farms, which is a very relevant part of the economy. So if we have less bats migrating to Alducra because more bats are being killed by Rumberi's wind farm, we will also have a financial harm to Alducra's people, as well as the environmental harm to the biodiversity. Hence, there is this transboundary harm. We must also consider that there are 4 elements which characterize the notion of transboundary harm, and all of them are present in this case. The first element is that of a physical relationship.
From where do you draw these elements, Council?
Your Excellency, they're from the draft articles of the UN.
The draft articles of the United Nations?
Yes.
Which organ?
Which are the draft articles?
Which organ of the UN? Security Council, for example.
We are an organ of the United Nations, but I am not aware of those articles.
Yes.
to which document are you referring? That's the question. You said that there are 4 elements. From where?
Your Excellency, I'm sorry, I have not specified and I don't have that information to present to you at this time.
So what is the point in entering this argument if we cannot give this court the authoritative source?
This is amply known, so I apologize for not citing it. I should have, but I presume that it would be safe to cite without the data. Regarding that, it is amply known, and also that the duty to prevent transboundary harm is a custom.
How will you prove that is a custom?
We can say that it is a custom because the ICJ statute calls a custom that is something that is a custom is a general practice accepted as law. And in a previous case, the case of the continental North Sea shelf, a custom was classified as involving 2 elements, which are the actual practice of that custom, of that concept by states, which means that this practice is consistent and repetitious through a reasonable period of time, and that the fact that these states see this practice as a law. So we can say
this case of North Sea continental shelf case involved which states?
Your Honor, it involved Denmark, the Federal Republic of Germany at the time, and Netherlands. It was in I'm sorry?
And what is the date of this case, please?
1969, Your Excellency.
Yes, but this case asks this court to look at the practice of states. What is the practice and the opinion juris that you are bringing to establish that there is a duty to prevent transboundary harm and these 4 elements that you are considering? Otherwise, I cannot see the point of mentioning them.
Mm-hmm.
You mean, Your Excellency, what is the habit of these states in order to bring forward the duty to prevent transboundary harm?
You mentioned a document that you did not prove that exists. Then you said there is a customary rule. I'm asking you to prove this customary rule. Where is the practice of states that demonstrate your point, Counsel?
For example, to cite another state that cites this practice is the Corfu Channel case that was between UK and Albania. And in this case, it is already an old case, it's from 1946. The ICJ decided that no states should allow their activities to harm other states. And if harm was ensued, the state who caused this harm would be liable. So this is an example of how the duty to prevent transboundary harm has been recognized by the court in previous cases with other states.
Okay, perfect. And these criteria that you are about to mention, the court mentioned in the Corfu Channel case, these 4 elements that you are about to explain to this court?
Your Excellency, I'm afraid I don't have that information.
Okay, you may proceed.
Thank you. Back to our elements, the first is the physical relationship between activity and damage. And despite the limited data and on the rates of bat mortality, considering especially Rumbei's restriction in monitoring the wind farm area, it's safe to say that the operation of the wind farm is effectively harming the bats and causing the spike on bat mortality. For we have the data from monitoring of the area up until Rodada and PECO forbade it, which points to a high rate of bat deaths. And also there's ample knowledge and studies which point to the fact that the operation of wind turbines is harmful to bats and avifauna in general. For example, an intersessional working group of the Eurobats in 2014 published guidelines for consideration of bats in wind farm projects, which in the least shows us that wind farms are a real and recognizable threat to bats. Also, we can take into account the precautionary principle. Philip Sands states that the precautionary principle aims to provide guidance in the development and application of international environmental law.
Who is that guy? Philip something.
Philip Sands, he is a professor, if I'm not mistaken, at the University College in London. He specializes in international law.
Okay.
And he states that the precautionary principle should provide guidance and development and application of environmental law, of international law, where there is scientific uncertainty. We have in the present case scientific uncertainty because—
Do you have any other source rather than one English author to substantiate your case, Consul, in order to prove the existence of this principle?
Yes, so we have Principle 15 of the Rio Declaration. This principle
is a soft law document.
It is a soft law document. However, we can also consider it in accordance to Article 38 of the ICJ statute while deciding this case.
So in Brazil, you have scholars and soft law to prove your argument.
Has this court ever considered the precautionary principle? This question is connection to the president's question.
Yes, this court has. I am afraid I don't have an example to cite for you right now. However, I will point out again that the ICJ allows for scholars and for soft law to be considered in ruling of the decisions, in that there are relevant points in order for us to consider.
Yes, that's not accurate because you made a specific laws that we cannot consider scholars. And has the court ever gave weight to a scholar in a decision before? Are you aware of that? The court used a scholar to determine that there is a legal principle?
Your Excellency, I'm sorry, I don't have that information, but we have to remember that scholars are an important part of the legal community in that they help write guidelines, they help lawmakers write laws, and they help research what issues should be approached in laws and in legal texts. So I understand your point. I understand that we are lacking in hard law for the present argument. I apologize. However, it is relevant to cite scholars and soft law.
Okay, you may proceed.
And about agent, please, about the precautionary principle, the Republic of Rumbeti will point out, I think, that it has acted in accordance with the precautionary principle as it applies to the climate crisis because the wind farm provides an alternative energy source, no? The wind farm could even benefit the species, so the bats, and biodiversity, but by helping to reduce CO2 emissions, no?
Yes, you are correct. Wind farms are not per se harmful, but this particular wind farm cited in this particular area is being harmful to bats. Also, going back to the principle I quoted from the Rio Declaration, Principle 15, this principle states that where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. So, as Alducra has stated in its diplomatic notes, we request that Rumbeti shut down the wind farm in order to implement mitigation measures. There are mitigation measures that are available and that will allow the wind farm to continue operation while also lessening their impact on bats and on other avifauna and local species in general. So there is no reason why we cannot conciliate both. And in the sense that there is scientific uncertainty, and when we see scientific uncertainty, we must take action. When there's a threat, Rumbeti has failed to comply with the precautionary principle. My next point, Your Excellencies, is that Rumbeti violated the Eurobats agreement. And also by allowing construction and operation of the wind farm, Rumbeti violated provisions of the Eurobats agreement. Paragraphs 3 to 7 of this agreement establish obligations to the parties. Among them is the obligation to conserve bat habitats and the naming of an appropriate body which is responsible to provide advice on bat conservation and management. During the construction of the first phase of Rumbeti's wind farm, the government and PECO declined Chiropteros Crusaders' proposal to implement mitigation measures. And also, after Chiropteros Crusaders' surveys showed the negative impacts caused on bats during the first 2 years of operation, Rumbeti did nothing about it. No mitigation measures were implemented. In addition to that, they forbade Chiropteros Crusaders to access the wind farm for monitoring, thus being clear their lack of cooperation and concern to commitments made under the Eurobats agreement. I'd also like to touch on the importance of cooperation. Principle 24 of the Stockholm Declaration states that cooperation is a means through which control, prevent, and reduce adverse environmental effects, and that international matters concerning protection and improvement of the environment should be handled in a cooperative spirit by all countries on an equal footing. So Rumbeti's lack of efforts in complying with commitments under the Eurobats also represents a lack of cooperation, seeing that Alducra reached to them diplomatically and suggested they take mitigation measures. However, they failed to cooperate in this suggestion.
But the answer to your diplomatic notes, they give your explanation. Don't you think that this fulfills the obligation to cooperate?
I think the explication on itself was very categoric and not cooperative, and not in a cooperation spirit, because it didn't truly take into account Alducra's concerns and as regards of the bat population. It simply stated their position very bluntly, and this is why we're here today.
And
so you are sorry, please go on.
Sorry, Agent, what about of the sovereign right of Rumbeti to exploit their own resource? I haven't heard about this sovereign right.
Yes, there is the sovereign right, and Rumbeti has the sovereign right. However, one country's sovereign right cannot be exerted if it is in expense of other countries' rights or of other countries' rights and territories and environmental concerns. So one can use their sovereign rights, however, in the measure that this doesn't affect other countries' sovereign rights and other countries' concerns. I will touch briefly on my last point, Your Honor, that is that Alducra did not violate international law in regard to its trade measures for tapagium products. Alducra's actions in trade and taxation are in accordance with the ARTA agreement and the CBD. In 2019, the country passed a statute which stipulated that in all tapagium produced without bat safe practices, there shall be a 20% tax. The Article 10 of the ARTA offers a list of exceptions as to when a country party to the agreement may apply taxes, and one of these exceptions pertains to the necessity to protect animal life. Your Excellency, can I wrap up, or do you wish I finish?
You have 30 seconds, please.
Thank you. Also, by the Article 11 of the CBD, Alducra has also acted in accordance with this article, since this article allows countries to take economic measures in order to protect biodiversity. If Your Excellencies have no further need of my assistance, I thank the court for its time and indulgence. It was an honor.
Thank you, Agent. Now, please, the first agent for respondent. You have the floor.
Good afternoon, Mr. President, Vice President, and members of the court. My name is Liara, and my co-agent, Beatriz Montenegro, and I are here in the presentation of the Republic of Rumbeti. Our oral argument shall consist in two different steps. Primarily, I'm going to demonstrate that the Republic of Rumbeti did not violate international law with respect to its wind farm project. Furthermore, my co-agents will explain that actually the federal state of Alducra violated international trade law with respect to its measure for tapagium products. First, I would like to address the accusations brought by the applicant. First, the violation of CMS. Second, the violation of CBD. Third, transboundary harm, and the claim that Rumbeti could use another sources of energy. About the violation of CMS, I must recall, Your Honor, that
before you proceed, counsel, sorry for interrupting you. Could you please explain if this court has jurisdiction to adjudicate this case? A court made of 3 judges.
Yes, Your Honor. According to the statute of the ICG, Article 34 and Article 36, this court has jurisdiction to answer pleads from countries about international law if the countries are parties for the UN nations, and which is the case right now.
Yes, but this is not the basis of jurisdiction. That's not exactly my question. My question is, can a court made by only 3 judges render a valid judgment? So what I'm asking here is, the judgment that we are about to render can be legally binded upon states? Because we are only 3, we are not with the full court. That's my point.
I'm sorry, I will not be able to answer your question.
Okay, may proceed.
May proceed, thank you. On CMS, going back to the point of CMS resolution, the accusation made by Alducra of violation, as already pointed to this court, resolutions are not binding. And besides the fact that they are not binding, CMS Resolution 7.5 itself recognizes that fighting climate change is an important instrument to the long-term survival of migratory species. And that is exactly what Rumberi is doing to these efforts for the wind farm project.
Yes, Council, but we can say that resolutions, especially in this case, can be used as an interpretative purpose and can even give raised obligations in certain cases. Don't you think that this is the case since you accepted the resolution?
I must recall, Your Honor, the Vienna Conventions on Law and Treaties, that all treaties and conventions must be written in the occurring of the facts and in the overall obligations of the countries. In this sense, I will present other documents which are binding that prove that Rumberi has a major point in saying that the resolution must be not considered to claim that Rumberi is guilty.
Okay, you may proceed.
Okay. Bringing CBD, Rumberi was also accused by ADUCRA of violating CBD. CBD is a binding convention, and CBD recognizes on its Article 20.4 the special circumstances of developing countries and even conditions the effectiveness of the treaty for the proper financial given by developed countries to developing countries' economies. I must recall, Your Honor, that there was no financial resources given by any developed nation for wind farm project made by Rumberi to make its efforts to find climate change, poverty eradication, make social and progress, doing its best efforts to sustainable development. Third point brought by the...
When did the CBD when did the treaty signed and when did it come into force?
I'm sorry, I don't have that information.
But it was into force in the period that you mentioned, correct?
When CBD was signatory, was that the question?
That was the question that Judge Robichet just made to you, and you could not give an answer. But yes. What I'm asking is, it was into force in the moment that
yes.
it arose.
Yes, it was into force in the moment that the issue was submitted. In this sense, I must also point that the preamble of CBD in Principle 8 of the Stockholm Declaration recognizes that social and economic development are the first and overriding priority of developing countries' party.
Is the preamble agent is binding for the court?
The preamble second to the convention, Vienna Convention Laws and Treaties, assures the guidelines of the treaty. So it's an interpretation, and that it's the guidelines for interpretation of the whole treaty.
Which part of the Vienna Convention says that, Council?
Article 31.
Which part of Article 31?
I'm sorry, I don't have exactly that information.
Thank you, Council.
It's also important to stress that Rio 92 recognizes that parties should be guided by the specific needs and special circumstances of developing countries' parties. We have a principle, international customary law, both principles that states for these facts, which are special needs of developing countries, special treatment, and the common but different responsibilities principle. But both principles were not being considered by...
These directions, Council. I'm sorry for interrupting you. You are going to use this argument that developing countries should be treated differently. Has this court ever decided a case in where such a treatment was given to any state or developing state?
I don't have exactly that information, but I have the case Gobikovo Najimarius project.
That were only 2 European states, so it's not my question. Are you aware of any other international court that uses this differentiation of developing and developed country that can help you?
No, I'm sorry, I don't know how to answer that question.
So you may proceed with your main argument, please.
Thank you. I'm going now to my third point that was brought by the applicant, which is transboundary harm, that Rumberi calls it transboundary harm, and that's hardly the case. One, because the applicant did not issue any data at all, basing their accusations only on the reports of an NGO. So they were not able to show a causal link between the allied wrongful act and injury, which was required by this court in the Nicaragua versus Costa Rica case, and also in the Pulp Mills case. I must also state to this court that besides the causal link between the allied wrongful act and injury, the accusation must be able to show a substantial change on its own environmental to claim to transboundary harm, which is again hardly the case. The only bats found that was in Rumberi's territory, and also the numbers 600, I must remember, Your Honors, could easily happen for many other reasons, as the main causes of bad mortality are actually climate change, collision with buildings, and wild or domesticated predators, according to the Cambridge study on wind farm.
Are you aware, Counsel, of any case of this court in which we have considered the relationship between the mortality of stocks that should be taken into account by this court?
The mortality of what? Sorry, I didn't understand.
The mortality of living sources.
No, I'm sorry, I don't have that answer.
Thank you.
I must also remember, Your Honor, that Rumberi conducted an EIA. Conducting an EIA isn't even an obligation, an overall obligation for the international law. Principle 17 of Rio 92 subjective to says that an EIA is subjected to a decision of a competent national authority. And also, Principle 14 of CBD states must do EIA as far as possible. Also, in the Pulp Mills case, this court decided that the due diligence principle, that is the overall principle that is personified by the EIA, must be considered when there is the chance that the construction might have impacted on transboundary harm.
Excuse me, Agent, what exactly is overall principle?
It's like the abstracted step of principle, and then when we come to the more concrete personification of the principle, it's the EIA. It's like the exercising of the principle. I would say the due diligence is the abstracted, and the EIA is the action when you also personify the principle. Okay.
Agent, speaking about as far as possible and as appropriate, was it so difficult to find another place to build this wind farm?
I must recall, Your Honors, that Rumberi is only a developing country with a few resources. The project was made in collaboration with a private entity, PCO, which was already the owner of those lands. The project was subsidized. So in order to make the construction on another land, Rumberi would have to burden the costs of buying another land. And Rumberi, as a developing country, as I already said, had only few resources, which it itself has to split in many policies. Rumberi chose the wind farm project because they are able to fight climate change, fight poverty, go to social development, and also reduce dependency on foreign sources.
But you did not answer the question of Judge Robichet about the other place to do this thing.
What is the limit? The limit of as far as possible and as appropriate.
The limit, as far as possible on CBD, talks about the conducted of an EIA. I'm not sure I'm understanding the question relating to the movement of the place. Would you please explain better, Judge?
No, I was thinking that it was not so difficult to relocate this farm, wind farm, in another, in an appropriate land.
As I said, Judge, indeed, there are plenty other lands, but the land was already owned by PCO, which is the private entity that did the work of construction with Rumbetti, subsidized by Rumbetti. And if it wasn't in those lands, Rumbetti would have to burden the costs of buying another land. So as a developing nation, it would be too high cost to burden, as it has to be a large land. So it was consciously chosen to be the best place available for Rumbetti resources and for the activities of the turbines.
Thank you.
Okay. Proceeding on my argument about not causing transboundary harm, I must also point that the overall numbers of bat mortalities near wind farms on the world. The bat mortalities on wind farms in Germany are about 600,000 per year. In United States, 200,000. In United Kingdom, 80. I must recall your honor that only less than 600 bats were found dead near the wind turbines in Rumbetti in a period of 2 years, which is a long period that could split the bat deaths in many other reasons, and a long period for ADUCRA being not able to point any transboundary harm in its own environmental. I must recall your honor again that what ADUCRA did was only pointed that the bat deaths constitute a transboundary harm, but not pointed to substantial interference on its own environmental, using only the reported of an NGO. In that sense, this court already decided in the Azun case, Colombia versus Peru, rejecting an NGO to present information for the case because the NGO was not a public international organization. NGO sources are not in the 38th statute, article of the statute, to be constituted as a legitimate source of law in this court.
But what about nothing? The time saved you.
Thank you, agent. The second agent for respondent, you have the floor.
Mr. President, Your Excellencies, may I please the court? I hope you can hear me well. My name is Maria Beatriz Montenegro, and on behalf of the Republic of ADUCRA, I will invite your honors to address with me the second issue that we have, which relates to ADUCRA's violation of international and regional law regarding its recent trade measures. So I'll be presenting our arguments in 3 major points to evidence that this court should not entitle recognition to ADUCRA. And those arguments are: 1, that ADUCRA violates the ARTA's aims and values as well as international law. 2, that the measures are not sufficient to evoke the agreement's exceptions. 3, that the measures are unlawful for violating the requirements of the chapeau of Article 10. My first point is that ADUCRA, by establishing those measures...
What do you mean by regional law?
Taking into consideration regional law, I'm directly specifying the agreement between the parties, which is the Archetypal Regional Trade Agreement, which is submitted to this court to be analyzed, and which is used by the applicant as a justification for its measures, saying that the measures are covered by the text found in the ARTA. So regional law...
Please?
Forgive me.
Please, go on.
Okay, thank you. And when it relates to the regional law based on the ARTA, we must also found in the ARTA some principles that are found also in international trade law, such as the principle of national treatment, which obviously prohibits differentiated treatment that is based on nationality. And even if...
Yes, Your Honor. Before starting, the language of the relevant WTO provisions differs from the ARTA provisions in any meaningful way. If so, Give us a few examples, please.
Well, the agreement based on the parties here present is in fact majorly based on some treaties of the WTO, such as the GATT and the TBT. And considering that the information we are allowed relates to only a small extract of the agreement between the parties, I would consider and I would inform the court that yes, the majority, if not all, of the agreement between the parties is in fact based on the GATT, the text. And that's why, in fact, the parties have already agreed that the jurisprudence from the WTO can be used as a legitimate source in order to interpret what the agreement says, because obviously it is not a very detailed agreement that gives a lot of information, making therefore jurisprudence a very legitimate source. So I will be bringing other resources, other cases of the WTO in order to share some light on some determinations and concepts inside the ACTA in order to provide you owners with a more broad view of what we're bringing. So this is exactly also what I'm describing with the principle of national treatment, because even if in the institute that ADUCRA passes says that the same treatment will be given either to domestically produced or imported tapagem, we will see that in this case, there is a discrimination de facto, because besides the discrimination injured in the discrimination text of the law, we must also consider the factual discrimination that happens in this case, because it creates a situation of inequality of opportunity inside the market of ADUCRA for ADUCRA's products and the products of its only competitor of tapagem, which is Rambeti. And the fact that ADUCRA's laws are established that the same measures goes regardless of the nationality must not neglect the fact that there is a discrimination, a factual discrimination that will create major damage to Rambeti. And this also shows that the measures are being used.
I do not understand this discrimination, because the record said that the tax and labeling requirements treat imported and domestic products the same.
Yes, I understand you. Exactly. We must not forget that, in fact, all domestic products of ADUCRA are already considered friendly, making therefore the only negative impact of these measures going to Rambeti, which is the only other producer of tapagem and seller of tapagem in the entire world. That's why this is the tool of protectionism, because it protects and gives more favorable conditions to the national producers. And this is also a matter of retaliation, because, Your Honors, we must be reminded that only now, after the fallout of diplomatic relations between the parties, has ADUCRA decided to impose these measures to farmers not of its own country, but to farmers of other country. The bad faith is also revealed by the fact that ADUCRA writes down in the statute that the measures goes to all other countries, but ADUCRA knows that the only other country that produces and sells tapagem is Rambeti. Therefore, it harms.
Counsel, but are this kind of retaliation prohibited by international law?
Well, a retaliation indicates bad faith, which goes against the principle of good faith. And in this fact, the retaliation that happens directly revolves around the issue that ADUCRA is discriminating against another country. Therefore,
so you are asking this court to declare that the principle of good faith was violated?
Of course, no, Your Honor, I respectfully disagree, because I will be presenting major arguments such as the violation of the national treatment, such as the non-sufficient requirements fulfilled in order to evoke the exceptions on the ACTA, nor the sufficient requirements in order to fulfill the requirements again of the chapeau of Article 10. And when we look into the Article 10 of the ACTA, we will see that there are two items that could be evoked by the
good faith principle.
Pardon me, Your Honor, could you repeat?
What's the legal base for good faith?
The principle of good faith, Your Honor, it is in fact a principle which in theory would not be binded by, but as it is recognized by this court in the statute, principles of law can be applied as a source. And in fact, this principle in the international trade law and world, we can consider it as a customary law, because it does fulfill the two notions of a reiterated practice of states, and obviously the opinion iuris, which would be the knowledge and the understanding that should be treated as an obligation between parties that are immersed in the multilateral system of trade.
Are you familiar with the Article 26 of the Vienna Convention of Law of Treaties?
I will not be able to specifically indicate the content of this article, but if Your Honor would like to enlighten me with that,
No,
please.
I'm fine. Please move on.
But do you have any case law that supports your finding that the principle of good faith is customary international law?
I understand that when it comes to good faith in International Trade Board, the WTO, which is the biggest body of commerce there is in the world, does treat it as relevant, as well as it considers the negotiation steps that indicates good faith. And when we look into this case, the negotiation step was also violated by Adukra, because
you haven't answered my question. I'm question about case law.
I will not be able to identify any specific case law that directly mentions the good faith principle. However, it is a principle, and it is in fact based on, it is a basis of international trade relations. And again, as a principle, should be considered by this court, even if it is not the primary source of law, which would be treaties. In this case, the biggest treaty there is between the parties regarding trade relations would be the ACTA. And when we look into the ACTA,
Agent, please, how the court should be interpret this fact? On 10th of January 2019, the government of Rumbetti and Peco informed the Chiroptera Crusade that they would no longer be allowed to access the wind farm for monitoring. How the court should be interpret this about your good faith about protecting bats?
Yes,
Right.
Your Honor. Well, pardon me. Does anyone wants to speak? Sorry.
Go on.
I can answer your Honor with a very direct answer, because the only expelled NGO was in fact Chiroptera Crusaders, and the NGO incited outrage from the Aldocan citizens. So Rumbetti had reasons to believe that the NGO was in fact being used to invade Rumbetti's sovereignty, because Rumbetti is a country that has its own accountability mechanisms, and Aldoca keeps trying to invalidate the country's sovereignty. So we know that there's in fact a great interest involved from the part of Aldoca to invent justifications for discriminatory measures. So the expulsion of the NGO does not mean that Rumbetti would be impeding, hindering the efforts of other bodies to analyze its situation, but in fact, Rumbetti has its own environmental bodies that do fulfill their obligations.
Mm-hmm.
Well, again, when we come to the ACTA, we will see that it has some specific items on its paragraph 10, and some of these items relate to protection of animal life or health, which would be item B. However, this paragraph also puts a requirement that the measure should be necessary, and Aldoca's measures is not necessary. One, because the level, when we look into which alternatives were available at the time, we will see that Aldoca's unilateral impositions were not its last resource, and actually many environmental international treaties do advise against unilateral measures in order to deal with environmental problems, such as Article 5 of the CBD, such as the preamble of the CMS, and Principle 12 of the Rio Declaration, that states that unilateral actions to deal with environmental challenges and outside the jurisdiction of the imposing country should be avoided. And Aldoca failed to demonstrate that other least harmful measures were not available to it at the time to protect the bats. And beyond that, the WTO case of the European Community's asbestos, the judges of the appellate body did frame the necessary measure as the only measure able to reach the goal when no other one could. And Aldoca has never shown this to be the case.
Yeah, but Aldoca is not part of WTO.
In fact, Aldoca is not part of the WTO, but Aldoca is part of the agreement between the parties, the Archetypal Regional Trade Agreement, that establishes the same thing, a measure that is necessary to protect.
Establishes the same text, but not the same interpretation of the appellate body. So why should Aldoca follow the interpretation of the appellate body, an organ that it's not a part to?
Because, Your Honors, when we're dealing with interpretations, we must have a source. If every country was left to deal with its own interpretation of a treaty because some other judicial body could not provide this interpretation, I wonder how the international sphere would be if we did not recur to judges, people of great intellectual knowledge of the law. It would be, in fact, chaos if we did not have any basis. And the basis that Rombeti is bringing right now is the WTO, because the ACTA is based on the GATT, and the ACTA recognizes that WTO can be used and shall be used, in fact, as a legitimate source of interpretation of the ACTA. This according to Article 15.2 of the ACTA, which is accorded for by the parties. So, beside the fact of there being
the WTO, the other thing, what you're suggesting, and I would like to clarify this. So you are suggesting that a state that is not a party to a specific international tribunal is bound to the interpretation of that tribunal. Is that you are suggesting to discard, Council?
Considering the written text of the ACTA, yes, that is what I'm suggesting, because it does say that interpretation of the WTO shall be taken into consideration when we are interpreting the ACTA, the agreement between the parties.
So, and why this court should take into account, a better question, are we bound to follow the interpretation of the appellate body of WTO in asbestos?
I believe that I believe that, Your Honor, the ICJ should in fact take the resolutions of the WTO into high regard, because it is established by both parties here present. They have agreed that the WTO should be taken into consideration when applying this treaty that is involving the party and is an object of controversy. So yes, the ICJ should take that.
With a case where we took into account the jurisprudence of the WTO appellate body?
I cannot give you that information, Your Honor.
Okay, thank you.
However, I do understand that it should not disqualify the usage of the WTO in this case, because in an analysis of case-by-case basis, we are now dealing with two parties that are contracted to the decision to evoke the interpretation of the WTO.
In the last minute that you have, Counsel, could you summarize your claims, please?
Yes, of course I can. The ADUCRA violates international and regional law because it violates the great principle of not discriminatory treatment between products of different nationalities. As it did create in a move of bad faith, it did create a negative conditions of market for Rumbeti, its only trade competitor, regarding tapagium, and its actions are discriminatory in an arbitrary and unjustifiable way, because it requires the same method to be applied by all other countries. Could I just finish my line of thought?
Okay.
Not only to the fact that it puts the same measures, which therefore makes it inflexible and too rigid, it also gives no differentiated treatment to least developing countries, therefore being arbitrarily discriminatory, taking into account already the jurisprudence of the WTO in the case of the US stream total. I thank you, Ernest. It has been a pleasure. May I please the court?
Thank you, Regine. Please, Epka, you have 2 minutes for rebuttal.
Thank you, Your Excellency. First, Your Excellencies, the respondents' disregard of the data of the monitoring of the NGO conducted seems very strange, since the NGO was allowed to monitor by Rumbeti itself, and monitoring is one of the requirements of the EIA, as stated in Article 14 of the CBD. Furthermore, Rumbeti was also the one that allowed...
Use the evidence of the NGO in this court?
Your Honor, when we consider that this is actually the only piece of evidence that we have that pertains to this court, particularly because Rumbeti didn't share any other sort of information, we should be able to consider this data. Also, as following this point, like I said, Rumbeti didn't give ADUCRA any other information in the project apart from the NGO monitoring data. So how can the respondent expect ADUCRA to finance a project it has no information on, and that the only information it has on wasn't given by the country, it was given by an NGO and it showed a relevant number of bat casualties. That being so, Al-Dhukra cannot be expected to help finance something that is harming such an important part of our local environment. Lastly, Your Excellencies, we must point out that the fact that the respondent is a developing country doesn't exempt them from complying with international environmental law. Once again, I thank the court for its time and indulgence. It was an honor.
Thank you, Agent.
The session is now adjourned. We will take the judges to a separate room to deliberate. Judges, you'll be taken there automatically. Okay, I think they all went there. Teams, congratulations. This is officially the end of your rounds. There is nothing else for you to do now.
Just freak out waiting for the results.
Yes, I have to wait for the results. We will have the ceremony at 4 p.m. after we count all the grades for this specific round. So how was it?
Cool. It's a bit tiring. Again, sweating right now. Yeah, but it was great. It was great. I think, yeah, I think that one of the judges mentioned this in yesterday's sessions, that it was very good to see women debating this and an all-women panel, at least with the oralist, and this is something that we are very glad to with.
Yes, after she said that yesterday, I counted the competition from all members, coaches, and teammates. There is 3/4 of female participants here.
Yeah. And also I think
the
girls from São Paulo, it's your first time taking this mood course, right? Yeah, ours too. So it's really cool to think that.
Yes,
perfect. Okay. So yes, now we'll have to decide the winning teams, and I've already got the list of best oralists, because as you know, the oralists are defined in the preliminary rounds, the awards for oralists. This round doesn't count for that. And the memorials, and yeah, that's all of the awards we have.
Cool.
Yes. How many goes to the
list
of best? I'm sorry. How many goes to the list of best oralists?
3 oralists.
Sure.
Yes.
Great. Cool.
Yeah, we're gonna have 3 oralists, 2 memorial positions, and obviously the finalists are both going to be awarded as finalists.
The question, Rui, we will receive feedback from the judges now, and after we will have the wrap up of the competition. Is that right?
Yes. The judges are going to come back for feedback. Then we're going to stop the video call here, and at 4 p.m. we should start the official ceremony. And then we're going to have everyone here. Okay, so the other team, if you're on YouTube now, once we go to 4 p.m. the ceremony, then you all join us here on Zoom so we can talk directly, at least for the awards. So after this, then you've got around a month and a half to study for the international rounds. Not a lot of time, but I think we've got enough material in terms of questions to research on. Well, not that the competition is, over, at least in terms of the rounds. I'll give you one piece of advice, which is to start whatever it is that you go and study, start through state consent in international law, because I think that that is related to almost all questions that you couldn't answer in a way, which is, why do I have to obey this? It's pretty much what the judges were asking. Okay, but why are you quoting this? Why does the state have to obey this? Because did the state consent to that? If it didn't, then why? Is anybody enforcing that? Because it's different than national law. Under national jurisdiction, you have to obey everything, whether you agree with it or not. But in the international law, that differs a little bit. So I think many of the questions relate to that. And of course, everyone here in the institute will be waiting to help you whenever you'd like to. So just feel free to reach out so we can help you out whichever way we can. Now that it's not up to us, it's Stetson, then we can talk to you directly and help out when how we can.
Is it the same case?
Yes, it's the same case. It's gonna be the same thing. And the difference is that you're gonna go through different evaluations in terms of memorial. So the grade you get here for your memorial, it's not gonna be the same for the international finals. They reevaluate all memorials. And they have different grades. So that's
how many countries are participating in the finals?
I'm not sure about how many countries, but usually they have around 20 to 30 teams in international finals.
And sometimes have more than one team per country, right?
Yes. Yeah. Usually I think 2, because you have the host university and the winner. Yeah. There are countries that will have at least 4 or 5 teams there. That depends on how many teams were in the national rounds. Actually, they aren't all just national rounds. They have like regional rounds. I'll check here on the website. Yeah, they have East Asia. What?
Is it your first time like conducting the moot court, not being in our place?
Is if it's my first time organizing?
Yes, organizing.
Oh no, I've done this a few years. Stetson and others.
You are very, very good.
Thank you. We have a whole team now that just got it in December and January as well, that is helping out with the competitions. So you're also welcome to join us as volunteers for other competitions. Maybe you'll still participate in Stetson again, but you can help out in other competitions because it's a very good experience. And you can also participate in other competitions. I think you might like the constitutional law one because it'll be a very diverse competition in terms of law fields. So yes, the rounds, you have like Central Asia, East Asia, Southeast Asia. I guess they're divided it like that, but it's not exactly national. I have a European round. India is a national round. Then you have Brazil, Colombia, Mexico. Yes. North America. You've got a good variety. So you should be soon, whichever team goes through, you should be soon getting updates from Stetson on how to work with their international rounds online.
For the constitutional law competition, the university must have a group, or you can just go yourself and...
So the constitutional law competition is going to be similar to the format we have here, and the format we also had at the tax law. It's going to be by teams, but we allow for teams to be made up of different universities. So you can have up to 3 universities in a team, and then teams, yes, these are the rules for the tax law competition, but they should be replicated for the constitutional law as well. So you can have teams from 5 to 10 teammates.
Thank you.
Yes. And it's going to be by the end of the year. We don't know if it's going to be in person. That's not up to us. If possible, yes, great. But that's more up to other powers of be than us.
Could you later? Oh, yeah. Could you later put it on the WhatsApp group, those competitions, the list of names?
Yes, perfect. But as always, you can also check out the website, brasileiras.com.br. You'll have all competitions there. So how was the experience of doing it online? What does it feel?
I think I love doing online things, online competition, but I think that the thing that we miss the most is actually traveling together and sharing the experience together. And doing network and etc. And later we would go out for a beer or something, because right now we can't. But so yeah, there was this downside, but on the overall, I think it's good. I think it provides a lot of opportunities for meeting different judges of other places. And this wasn't the case, but it could be we could have international judges. In fact, we had international judges, didn't we?
Yes.
Many.
A few.
Exactly. So I think it's a great opportunity that we maybe might not have had if it was, in person.
Yes. Yeah. Yeah. It loses a bit of the feeling that comes with the in-person events, obviously, especially because you don't have much time to chat with the judges, not even on a one-on-one basis. It's all very standard because, well, after the round is over, we need to close the room because we need to move on to another round. So you don't have the in the corridor to talk to them. Yeah. But as you said, there are some benefits. You can manage your time better. You don't have to be running from one side of the campus to the other. It's easier because you're at home and
I think we can also control our posture better because we can see ourselves talk, and then we can see, oh, okay, I'm too much, I'm too little, and that helps. But also, since like for us and for the other team here, it's been our first time doing a competition, we don't really have what to compare it to. I mean, we've talked to people who have done it before, but since as a first experience, I don't feel that we missed out on much. I feel like it was still very valid. It was still very valuable.
Great. Yes. Yeah, many of the people who joined this competition, the last one, it's their first time at all in wood-court competition. So they're starting like this. They don't know exactly how the in-person events are. But one of the things that we did with the text law, which was the first one, was we had to use technology for all of it because it was so different. And we had the online forms for the judges, the online score sheet, which helps out a lot because we don't have to add up the points, we don't have to do anything. And it also enables us to give you the scores almost immediately, which was impossible with like printed score sheets. That is just not possible to do something like that, because now you have through the app you can get all your scores, so you know which criteria you're not doing well, which criteria you were amazing at. What do you think about that? Did you actually use that to your advantage to get better?
Yeah, I think it was very helpful because we could, and like pairing that with the feedback, you could see, oh, he said this thing and really I didn't get as much points in this aspect, so it made sense if I tried to do this and this and that and that. I thought it was very helpful.
We talked to a judge on telephone, on WhatsApp, to ask for feedback, and he was really, really nice. I don't remember his name. Bia, do you?
Yeah, it was Francesco Schmidt. I don't know if I'm pronouncing that correctly. I don't know where exactly he's from, but yeah.
Yes, I think he's Italian. Yes, some of the judges said that for you guys to contact them, right? Because that's the only way they can give feedback, extra feedback.
Yeah, I contacted him in Portuguese and he answered me in English. I was like, my God, I think he's not, his mother language is not Portuguese. It was great.
Oh, you thought he was Brazilian? Okay. Yes, but all the judges that said that you can contact them after you go to the international routes, whichever team goes, you can still reach out to them. They're usually very receptive. Let me just answer something the judges are asking. Asking if there was a specific award for best oralist of the final round, because you have that at Stetson, but that's because they have many more teams in international finals. Here we're going to have the overall winner of the competition, not a specific oralist for the final. Okay, I'm going to go to the judges room just to check on something. I'll be back soon. Olá a todos os oradores, por favor, podem ligar suas câmeras. Paulo apareceu aqui agora. A rodada está encerrada, os juízes vão aqui apenas dar um feedback para vocês, não vão dizer o resultado ainda, para que vocês fiquem um pouco mais ansiosos, aguardando até a cerimônia de encerramento. Mas então eu passo agora a palavra para Paulo, presidente, que dará início aos feedbacks.
Bem, pessoal, primeiro, parabéns pelo trabalho, pela dedicação, estar em uma competição como é a Stetson, é motivo de um impulsionamento acadêmico e profissional muito grande. Então, parabenizo vocês pelos trabalhos que vocês apresentaram e, claro, por estar na final, não é? Quer dizer que o trabalho que vocês fizeram até então foi exitoso. Foi uma disputa muito bacana, foi difícil. A gente estava ali no judging room, né? E, enfim.
Paulo, desculpa te interromper. Tu não quer te apresentar primeiro?
Sim, vamos lá. Bem, Paulo Oliveira, eu sou professor de Direito Internacional, cerca de 10, 11 anos já lecionando essa matéria. Enfim, gosto muito de Direito Internacional, sou um apaixonado e entusiasta do Direito Internacional e sou entusiasta também dos multicortes em gerais, né? Eu sou coach da equipe da Federal da Bahia, no Jessup, desde 2014. Tivemos muito bons resultados com a equipe, enfim. Então, eu consigo identificar de fato que não é fácil estar aí no local de vocês, mas é algo muito prazeroso e eu vejo alguns ex-alunos hoje ao redor do mundo, empregados, bem empregados, enfim, felizes no que estão fazendo, e isso tudo foi impulsionado por um multicorte, que foi o JESP. Mesmo assim, participe de outros tantos, né? Amanhã mesmo eu estou num treino da BARB para o VIS, que é de arbitragem, né? E no final do mês estarei aí no Jessup novamente, nos National Rounds. Espero que minha equipe tenha o prazer de ser julgada novamente por Lucas, que na minha visão é um dos grandes judges aí de toda e qualquer competição. É uma pessoa fenomenal, é uma pessoa que você fica feliz de ter no bench, entendeu?
Eu não vi muita felicidade hoje, não, mas depois eu converso.
Enfim, então... E Juliette aqui, fica registrado o meu prazer mesmo de estar aqui com o Lucas. E Juliette, uma pessoa extremamente querida, extremamente aplicada, uma profissional em tanto, faz um belo trabalho em Direito Internacional aqui na Bahia, junto com outros professores que eu acho que conseguiram impulsionar aí o Direito Internacional, o estudo, não só do lado teórico, mas também do lado prático. Então, Juliette, Lucas, registro aqui o meu real prazer de estar fazendo em uma final de competição com vocês. Enfim, eu só parabenizo vocês, então, foi um round realmente muito difícil. A gente estava ali deliberando e estabelecendo requisitos, né, para conseguir ter alguma equipe que tivesse pontos, né, maiores do que a outra equipe. Eu só faço aqui um puxão de orelha para uma final. Acho que o direito internacional em si, a base, faltou bastante, né? Então, institutos e conceitos básicos de direito internacional não foram respondidos. Enfim, leiam, saibam tudo o que vocês estão trazendo, entendeu? Saibam tudo, leiam tudo. Enfim, tenham conhecimento de fato que vocês estão trazendo para o bench. Era um bench muito preparado, não por mim, claro, mas por Lucas e Juliette. Vocês tiveram outros tantos benches, então, enfim, fica aqui meu pequeno puxão de orelha, mas, claro, parabéns aí pelo trabalho, por estarem na final e fazerem uma final tão bacana.
Juliette, s'il vous plaît.
Você está mutada, professora.
Melhorou. Isso é clássico, é o clássico desses encontros virtuais. Então, estava agradecendo em francês o Bad Judge, merci. Ele que se autodenominou assim. Então, eu gostaria também de agradecer a organização pelo convite. É muita responsabilidade de participar da final de uma competição assim tão importante. É sempre um prazer. Eu aprendo muito, muito. E dividir essa mesa com duas pessoas que eu admiro muito. Então, agora, eu vi como você é ruim, juíza, mas é com esse tipo de juízo que aprendemos muito. Então, parabéns, Luca, Lima, foi um prazer e realmente adorei compartilhar essa mesa com você. Paulo, apesar dos meus 30 anos, acho que esse anos não rejuvenesce muito. 30 anos que eu ensino direito internacional, dá vontade de me suicidar. Aprendi muito com você, porque estou aprendendo ainda, adoro participar dessas sessões com você como coach, porque vou me apresentar também um pouquinho, sou francesa, e já fizeram um cálculo da minha idade. Na minha época, essas competições não conhecia, então, pelo menos não chegaram até a França, e vocês quatro, hoje, Marcela, Laura, Liara e Maria Beatriz, estão de parabéns, porque aproveitaram dessa oportunidade de aprender muito. E verdade, Paulo, todos que participaram lá desse GESUP, de todas essas competições de direito penal internacional, direito ambiental internacional, hoje tem uma carreira maravilhosa, estão realmente porque primeiro em inglês faz esse tipo de competição, só em inglês já estão de parabéns, e requerem também muito conhecimento, muita segurança, então é fantástico. Então, isso, me apresentar rapidamente. Então, fui professora na Sorbonne, onde eu fiz todos os meus mestrados e doutorado, e houve um acidente, ou incidente, vou dizer, me apaixonei por um baiano, cheguei há 20 anos atrás aqui na Bahia, e onde estou ensinando direito internacional, direitos humanos, e hoje estou muito orgulhosa também de ser a presidente da Comissão de Direito Internacional do Instituto dos Advogados da Bahia. Rui também, indiretamente, mas já participou dessa comissão, porque ele organizou o congresso virtual, primeiro congresso virtual de Direito Internacional e Relações Internacionais, o CODIR, e acho que era disso que Paulo se referia, para justamente vitalizar, difundir esse direito internacional aqui na Bahia, no Nordeste, e graças a essa virtualidade, conseguimos fazer uma parceria com o Paris 1 Panthéon Sorbonne, e queremos agora, Lucas, te convidarei também para participar, ter a obrigação de participar do segundo CODIR. Já ameacei, não é convite, é ameaça mesmo.
Ameaça aceita.
Ótimo. E, então, sobre essa competição, antes de falar dessas prestações atuais, eu gostaria de realmente parabenizar a organização, em particular Rui, pela excepcional organização, realmente tudo perfeito, é impressionante. Mas agora que eu te conheço cada dia mais, Rui, isso não me surpreendeu, né? Mas tem que realmente reiterar meus parabéns. Pela equipe também, né? A Marina também, parabéns. tudo ocorreu muito bem e tudo foi um prazer. A disputa em si, o caso, muito rico, muito bem elaborado, parabéns. Sobre a disputa de hoje, afinal, é uma disputa muito interessante, muito rica e muito equilibrada. Né? Não posso dizer o resultado, mas acho que todos os meus colegas vão concordar comigo. Não foi fácil realmente decidir quem realmente se destacava. Às vezes fica mais óbvio, hoje a disputa foi extremamente equilibrada. E primeiro também gostaria de dizer que, segundo que fiquei feliz de ver só meninas, né? Women Power, parabéns nesta final. Marina está feliz também, eu vejo o sorriso. E isso, então, o que foi, acho que todas têm uma desenvoltura oral muito boa. Não sei quem respondia ok, bom evitar. Vamos evitar esse tipo de expressão familiar, mas fora disso, a postura, tudo realmente impecável. Algumas perguntas aparentemente perturbaram vocês, então talvez estudar as normas básicas, né, a Convenção de Viena, né, etc., tem que conhecer bem, mas é verdade que era um caso extremamente rico, né, que envolvia muitos tratados, não somente de direito ambiental, mas também de direito comercial, de direito econômico internacional, que não é fácil, muito difícil, mas vocês se deram bem. Então, parabéns, porque eu sei a dedicação que isso cobra de vocês, muito tempo, muita dedicação, muitos sacrifícios, enquanto todo mundo está indo para a praia, pelo menos para os baianos, não sei de onde vocês vêm, mas bom, pelo menos nesse confinamento, vocês tiveram uma boa razão para ficar presos em casa, mas eu sei que, pelo menos aqui na Bahia, é sempre difícil, porque tem que estudar durante o carnaval, durante as festas, no final do ano, etc. Então, vocês estão realmente de parabéns e sucesso. Eu quero brasileiros lá na final. Onde é? Nos Estados Unidos? Em que cidade?
Seria na Flórida, mas vai ser online agora.
Que pena para quem vai ganhar. Mas eu quero vocês virtualmente na Flórida. Um grande abraço e boa continuação.
Olá a todos. Antes de mais nada, antes de me apresentar, não me odeiem. Eu fiz o papel que me foi requerido e o Rui me chamou aqui exatamente para fazer isso, porque eu, há 3 anos, julguei o Rui na Stetson. A Stetson foi a primeira competição que eu participei como juiz, e desde então eu gosto muito de competições, e eu acho que a melhor coisa que um juiz pode dar é estudar o caso e testar os casos de vocês. E pobre Laura dizer, teu caso não tem sentido você continuar aqui se você não me der esse ponto aqui. Eu acho que faz parte um pouco te preparar para isso, porque acho que as rodadas nacionais servem para isso, para que vocês lá fora estejam melhor preparadas. Meu nome é Lucas Lima, eu sou professor de Direito Internacional na UFMG. Eu fiz meu doutorado na Itália, e ao final do meu doutorado eu participei de um caso na Corte Internacional de Justiça, em que eu trabalhei exatamente nessas questões procedimentais que vocês analisaram, e o que eu vi hoje de vocês foi um pouquinho daquilo que eu vi na AIA, e eu queria deixar aqui meus parabéns. Mas queria também dizer que é uma grande satisfação participar dessa banca com o Paulo e com a Juliette, que eu conheci hoje. Juliette, foi um prazer. As nossas deliberações foram fantásticas, pena que vocês não podem saber, mas foram muito difíceis. Mas foi muito bom estar com pessoas que estamos em sintonia, estávamos na mesma humor, etc. Isso foi algo muito agradável, é sempre bom fazer isso. Eu queria aqui também deixar registrado a minha alegria de poder ter aceito esse convite com a direção do Rui, e agradecer também a Mariana por todo o apoio, porque essa é uma coisa que eu tenho muito afeto. O Rui também teve esses probleminhas comigo, ele também passou uma noite me xingando, como vocês talvez eventualmente passem, mas no dia seguinte nós tomamos uma cerveja, volta e meia trocamos mensagens, etc. E é uma das coisas boas dessas competições, dos contatos que vocês fazem, além de tudo aquilo que vocês aprendem no processo. Feedback. O feedback é o seguinte, os meus dois colegas já falaram muito perfeitamente o que é que faltou, e a gente entende por quê, era um caso que envolvia direito internacional geral, fontes, jurisdição da corte, procedimento, mais direito ambiental internacional e direito do comércio internacional, ou seja, era muita coisa, e a gente entende isso, mas a gente também tem que mostrar para vocês onde é que estão esses falsetes, esses pontos difíceis argumentativos. Qual foi o critério que eu, particularmente, eu falo por mim, não falo pelos meus colegas, utilizei na hora de decidir qual seria o melhor time? Eu tive que utilizar um critério de balanceamento e representatividade. Eu acho que o Brasil está fazendo cada vez mais um bom nome em competições, isso envolve participação, mostrar que a gente não é um país atrasado que só recebe direito internacional dos outros. E aí o critério que eu utilizei foi qual é o time que talvez estivesse mais balanceado para a próxima fase. Porque foi muito difícil, os dois times foram excelentes, eu gostei muito do que eu vi aqui hoje, aprendi muito com vocês, eu reforço esse argumento da Juliette, a gente aprende muito, a gente estuda, vocês foram ver, são 2 horas de uma sexta-feira que nós estamos aqui de gravata, bermuda e chinelo, para trabalhar com a juventude de direito internacional, é um pouco de paixão pela causa. Eu sou um entusiasta da Stetson, julgo também a Jessop, como o Paulo falou. O Paulo ele me dá assim elogio antes da competição. Depois ele esquece de mim por um ano. No ano que vem, em março, ele começa a falar comigo de novo. Brincadeiras à parte, o Paulo é um amigo, e essas são as melhores coisas da competição, os contatos que vocês fazem, o que vocês aprendem, e que isso sirva para vocês irem para outras competições e para que vocês aumentem a rede de network de vocês. Foi um prazer conhecer vocês, e no que eu puder ajudar vocês nas carreiras de vocês especificamente, me deixem saber aqui nas Minas Gerais, tem uma série de atividades, direito internacional, etc., para mim é um prazer continuar em contato com times tão bem preparados, mas que para a eventual equipe que vai para a Flórida virtual tem que agora sentar e dar uma estudada no básico para representar ainda mais o país, para estar preparado para todo tipo de questão, não só do caso, não só as linhas principais do caso, mas tudo aquilo que envolve os arredores do caso. E vocês hoje tiveram muitas perguntas a explorar e, sobretudo, faltou case law, faltou o caso Whaling, faltou o caso da Costa Rica e Nicarágua envolvendo impacto ambiental, faltou a decisão da Corte em reparação sobre dano ambiental, faltou a Corte dizendo precautionary approach, faltou as decisões do Tribunal do Mar falando de precautionary principle, a Corte Internacional de Justiça nunca reconheceu o princípio da precaução como tal, existe um grande debate sobre isso que a gente nem chegou, e que, eventualmente, quem for entrar nisso vai chegar. Essas questões vão bater para vocês. Eu não sei se isso estava no... Eu não li não sei se eu estou revelando algo do Judge Bench, mas eu não li o Judge Bench, eu só li o caso dessa vez, então não sei se eu revelei algo que eu não podia, e então não violei nenhuma regra, espero. Faltam 3 minutos para a cerimônia de celebração, eu vou parar de falar antes que o ódio cresça ainda mais, mas repito, foi um prazer para mim estar aqui hoje. Não me odeiem, eu tendo a ser uma pessoa legal, o Rui pode confirmar.
Muito obrigado, Lucas. Muito obrigado a todos.
Só um adendo. Lucas no Jasp é conhecido como o meu malvado favorito, viu? Porque tem as perguntas e tal, por vezes capciosas, difíceis de serem respondidas, mas todo mundo adora ele de paixão. E, enfim, quem tem algum ressentimento acaba quando começa a confraternização e pronto. Certo.
Aqui vai faltar isso, né? A cerveja do final, mas, enfim, fica para o futuro.
Pois é, muito obrigado a todos, Lucas, Juliette, Paulo. Essa rodada final eu escolhi a dedo, com pessoas que eu já tinha conhecimento, eu tinha contato, que são bastante queridas, porque eu sabia que ia ser uma experiência única, bastante equilibrada para todas as equipes. Então, agradeço a todos pelo convite. Em meu nome de Mariana, e em nome de todo o Instituto Brasileiro de Multicorte, que nós formalizamos no último mês. e que está responsável por realizar a Stetson aqui. Bem, sem mais delongas, aqui vocês estavam para ouvir os juízes. Vamos dar por encerrada essa transmissão e nos vemos daqui a pouco na cerimônia de encerramento. Equipes, eu vou mandar o link através do WhatsApp. Tchau, tchau.